Hello and welcome to TaxPundit.org. TaxPundit is India's most popular and trusted database of income tax case laws. In today's video, we will be analyzing a landmark case study that provides critical insights for tax professionals. Let's dive right into the details. The case under discussion is MA Projects, P. Limited versus Deputy Commissioner of Income Tax, pronounced by Delhi Tribunal on the 13th of May 2026. The Assessee, Messrs. MA Projects Private Limited, engaged in real estate development, received Rs 50 lakh as share application money from Indian Hosiery Private Limited for allotment of 50,000 equity shares at a premium of 90 rupees per share. The assessing officer issued a notice under Section 143(3), requiring proof of identity, creditworthiness, and genuineness of the transaction. The assessee furnished extensive documentation, audited financial statements and income tax returns of the investor, confirmation including board resolution authorizing the investment at premium, copy of Form 2 for share allotment, bank statements of the investor, and the investor's net worth of 300 rupees 0.69 lakhs as on the 31st of March 2010 and 345 rupees 0.95 lakhs as on the 31st of March 2011. The investor responded directly to the AO's notice under Section 133(6), confirming the transaction and providing justification for the premium. Despite this, the AO concluded that the assessee was not doing genuine business and that the investor had only nominal bank balances on normal days, thereby doubting creditworthiness. The Commissioner of Income Tax, Appeals, upheld the addition of Rs 50 lakh under Section 68, leading to the appeal before the ITAT. The core issue was whether the assessee had discharged its burden of proving identity, creditworthiness, and genuineness of the share application money. The ITAT applied the Delhi High Court decision in CIT vs Gangeshwari Metal P Limited, 361 ITR 10, which held that once the assessee furnishes all necessary documents and the AO does not conduct further inquiry, the addition under Section 68 cannot be sustained. Here, the AO issued a notice under Section 133(6), and the investor complied fully. The ITAT distinguished the Supreme Court ruling in PCIT vs NRA Iron and Steel Private Limited, 412 ITR 161. In NRA Iron and Steel, the investor companies were non-existent and identity was not proved. Here, the investor was tax assessed, had a net worth over 300 lakh rupees, and responded to the AO's inquiry, proving identity and creditworthiness. The ITAT reiterated that the initial burden lies on the assessee to prove identity, creditworthiness, and genuineness. Once discharged, the onus shifts to the revenue. The assessee provided audited financials, ITR, bank statements, board resolution, and the investor's net worth was sufficient. The AO's observation of nominal bank balance was insufficient to rebut the evidence. The appeal was originally dismissed on the 9th of August 2019 but was recalled via MA number 92, Del. 2020 dated the 10th of October 2023, specifically to examine the applicability of Gangeshwari Metal and NRA Iron and Steel. This procedural history underscores the tribunal's commitment to correctly applying judicial precedents. Respectfully following the Delhi High Court decision in Gangeshwari Metal, the ITAT deleted the addition of Rs 50 lakh. The appeal was allowed, and the order was pronounced in open court on the 13th of May 2026. Question: what was the primary issue in this case? Answer: the primary issue was whether the addition of Rs 50 lakh under Section 68 of the Income Tax Act, 1961, for share application money received from Indian Hosiery Private Limited, was justified. The ITAT held that the assessee had proved the identity, creditworthiness, and genuineness of the transaction, and thus the addition was deleted. Question: why did the ITAT apply the Delhi High Court decision in Gangeshwari Metal? Answer: The ITAT applied Gangeshwari metal because, in that case, the Delhi High Court held that once the assessee furnishes all necessary documents and the AO does not conduct further inquiry, the addition cannot be sustained. In the present case, the investor responded to the AO's notice under Section 133(6), and the AO's doubts were not supported by any adverse findings. Question: How did the ITAT distinguish the Supreme Court decision in NRA Iron and Steel? Answer: The ITAT distinguished NRA Iron and Steel on facts. In NRA Iron and Steel, the investor companies were non-existent, and the assessee failed to prove identity. In the present case, the investor was a tax-assessed company with a net worth of over 300 lakh rupees, and it responded to the AO's inquiry, proving its identity and creditworthiness. Question: What documents did the assessee provide to discharge its burden under Section 68? Answer: The assessee provided audited financial statements, ITR of the investor, confirmation from the investor company, board resolution authorizing the investment, copy of Form 2 for share allotment, bank statements of the investor, and a copy of the investor's scrutiny assessment order under Section 143(3). Question: What is the significance of this judgment for taxpayers? Answer: This judgment emphasizes that taxpayers must maintain comprehensive documentation to prove the three ingredients of Section 68. If the assessee discharges its initial burden, the revenue cannot make additions based on superficial observations. The decision also highlights the importance of investor cooperation, such as responding to notices under Section 133(6). Thanks for watching this video. You can download the full legal analysis, the official case law, and a concise case digest PDF directly from our website, TaxPundit.org. If you have any questions, feel free to write to us at TaxPundit@TaxPundit.org, or message us on WhatsApp at 9326306668. Don't forget to subscribe to our channel for more authoritative legal updates.